I have been asked by Lianne, and who's been very kind, um, and has asked me to give a short talk and its presentation regarding the Renters' Rights Bill, which is something that's coming very soon, certainly within this year, um, to to the legislation books. And I think it's something that is going to change the way that tenancies and lettings run for everyone. For everyone, landlords are going to be as affected, I think, uh, as tenants. And I'm not sure. My own view is that I think that this is going to be at a very difficult period for landlords, but it's coming, and it's something that landlords need to know about and need to get to grips with as we go through. So I'm really grateful to Lianne and the team for inviting me to come and speak. Um, I am a solicitor, and I'm with a firm called Spector Constant Williams. We're based in London. My practice is property litigation, and that covers a whole range of topics. But part of that is to deal with short-term tenancies and all the issues that arise from short-term tenancies, by which I mean not low leases, so ASTs as they currently stand, and licenses and other short-term lettings. So um, the firm, as I say, is based in London. We deal with basically anything to do with property, and amongst other things. The Obviously look us up if you need any help, and I'm around. And I think Lianne may be uh, asking for some questions, and that they'll be referred to me, and I will give as full an answer as I can, and after we've done this talk. So thank you for coming along. Um, the first thing I want to say is that what is being proposed by the government is a sea change in how tenancies are dealt with. So that what you now understand as being an AST is not going to be an AST any longer, once the act is passed. And in terms of the timing, it's likely, we think, towards the end of this year to come into force. Obviously this is parliamentary process, so we have no idea that it's going to be this day in particular, but we think towards the sort of end of quarter three, beginning of quarter four of this year is when it's going to come in. Um, the the position will be that ASTs, and that's both new and existing ASTs, will no longer be ASTs, so they will not have a fixed end date. They will all become periodic tenancies. And what that means is that it will run month to month. A tenant will be able to end that tenancy at any point from the date the tenancy is entered into by giving 2 months' notice. A landlord can end a tenancy only if the landlord has grounds for ending that tenancy. Now, currently, you can serve a Section 21 notice, and that is often called no fault, but I prefer to know it as no reason. So that's a no reason eviction. You can serve a Section 21 notice, terminate the tenancy after the fixed term has ended, and that will be the end of it. The new regime means that the landlord must have a reason to end a tenancy. All of the reasons that are currently available to a landlord in those circumstances will remain. Some will be amended, and these are set out at the Schedule 2 of the Housing Act 1988, and ones that you'll know about are such things as rent arrears exist, is that the landlord wants to use the property for its own purposes or for family members. But now, well, I say now, when the new act comes in, only those grounds can be relied upon. So there is a new ground, which is that the landlord wishes to sell the property. So that is then available. But the notice periods have changed. So whereas you can currently end a tenancy on 2 months' notice under a Section 21 notice, dependent on the nature of the breach, you have different periods of notice that you have to give. So if you want to sell the property, you have to give 4 months' notice. If you want to serve notice because there are rent arrears, there are different grounds, and it depends which ground you're relying on, but it's gone from 14 days up to 28 days notice. And in particular on the rent arrears, whereas previously 2 months rent arrears meant that the court had to give you an order, it's now 3 months rent arrears. So there are some changes coming in that will affect landlords fairly dramatically. So what also will happen, because Section 21 notices are no longer going to exist as a mechanism. And I apologise to Christian, who's manfully trying to fit the slides with my talk, and I'm flitting from one to another, so I apologise to him. If we can just go back, please, one slide. So the end of Section 21, no fault evictions, means that the judicial process for getting a possession order, which you can currently rely upon once you've served a Section 21 notice, and that's the accelerated possession procedure, which is arguably, and I use that advisedly, arguably quicker, that also will fall away. So every case, every application to the court for a possession order will now have to go specifically before a judge at a hearing and be determined as to whether the landlord has that particular ground that they can rely upon and whether they've made out that ground. What this will mean, in my view, is that the process of getting a possession order is going to be so much more difficult. And the courts, I think that the courts will be inundated with claims. I know from personal experience of my practice that very often landlords will serve and rely on Section 21 notices, even where there are situations on which another ground could be made out. So antisocial behaviour, or a breach of other terms of the tenancy, so subletting, or there are rent arrears. But we know that some bits may be disputed. If the tenant disputes it, we could be months before we get before a judge. So we use the Section 21 notice instead. I think that hasn't been factored into the government's thinking on this, and I suspect that obtaining a possession order will be quite a struggle and will take a long time once this comes into law. I hope I'm wrong, but unless there is some investment in the court system fairly quickly, I think this will be a struggle. Okay, I will move to the next slide now. Thank you. So I have mentioned that there'll be new grounds, and as well as the existing grounds for possession. Ground one, which is use for a family member, that's been changed to the extent that the legislation is going to clarify and gives guidance as to who a family member is, and it specifies that, so which it doesn't in the existing legislation. So that is actually quite helpful. And there's a new ground 1A proposed, which is where you're selling the property. That is a ground for possession in the new legislation. Some of the existing grounds that will change relate to student lets. I'm not going to go into detail about those, but they are something that will need to be looked at as and when you, as a landlord, look to take possession. One thing I would mention here is that one of the things about the Act I'll talk about later is enforcement. Seeking to rely on a ground that you have no right to rely upon will become a criminal offence. So if you seek to rely upon a ground that your family member wishes to use the property, and in fact you have no intention that they will, and then they don't, but the tenant has left, that could face you with a criminal prosecution by the local authority, and the local authority can impose fines of up to £40,000. It's unlikely that they go straight up to that level, but it is available to them. And that's without judicial process. So they can fine you because they think that that's the right thing to do. And then it's in the landlord's hands to try to row back or get them to reduce that and possibly apply to tribunal. So this is quite a big thing for landlords that's coming in. And if I can have the next one, please. So one of the things, again, that's coming in is how a landlord will increase the rent as a tenancy progresses. This process is already available to landlords. You can serve a notice under Section 13.2a, I think it is, or 13a2 of the Housing Act once a year to increase the rent, and the tenant can challenge that or not. The process might change, but the fundamental point is that will still be available. But the process whereby landlords would effectively terminate a tenancy and offer a new tenancy as a new rent, that's effectively gone, because the tenant has no reason whatsoever to agree a rent increase without the landlord serving notice and that rent increase being reasonable. The landlord cannot get rid of a tenant because the rent's too low. Whereas now you serve a Section 21 notice, there's no reason, you can then get a market rent. So you can serve a rent increase notice once a year. The tenant, if they wish, can challenge that in the tribunal, and that rent increase will only come into force after a tribunal has determined the reasonable and the reasonable market rent. Tribunals historically have been tenant friendly. I make that point. So again, yet to be seen how many tenants will challenge, how this is taken up, and how landlords are going to react to this. But it is a change in how we as landlords deal with things. The other thing I should mention here is that there has been an amendment to the government's proposed draft bill, brought by the government, of course, which is that landlords should only be able to collect a maximum of 1 month's rent in advance. So if you collect more than 1 month's rent in advance, so for example, you let the property on the 23rd of the month and you wish to you wish to start the rent from the 1st of the month, you couldn't at that point collect 5 weeks rent. You would have to take a week, and then on the 1st take the next month's. there will be no situation that I see a lot of tenancies at the moment where it's a monthly rent, but it's payable 6 monthly in advance. So we get two rental payments throughout the year, especially in cases where there are no guarantors. In the cases I've seen, they've been fairly young tenants, and this has been a way of making sure that the rent is collected. That will not be possible once the Act comes into place, into force. So, and I think that amendment is probably the only amendment that's gone through the Lords that is likely to pass into the actual statute books. The other thing that is going to come and change the way that we all do things is a ban on rental bidding. So where you advertise a property for rental, the rent that you put in the advert is the maximum amount of rent that you can charge for that tenancy. So how that works in practice, the agents that will obviously be talking to you as landlords about this, but it may in practice mean that rents are driven up immediately, and that you go at the maximum you can possibly achieve and try to get lower, and try to get that, but obviously accept lower if you need to. But there are fines of up to £7,000 if you advertise a flat at £1,000 a month and rent it for 1,200. Even if you've got 18 people wanting to rent that flat. So that is a big change. If we can move on to the next one, please. I'm not going to go into a great deal of detail about repair standards. The reason for that is that this has gone out to consultation. So the AWAB's law, which is the resolving hazards in the property, and the decent homes standard, both of them have gone out to consultation. And once that has finished, once that process is finished, we will get a decent home standard, and AWAB's law will then apply to the private rented sector. This is likely to not come into force at the same time as the rest of the Act. So I don't know is the short answer as to how this particular part of the Act is going to end up. No one does at the moment. So just be aware that repair standards are something that will come in, and will be able to be enforced by the local authority as they are now, but also directly by the tenant, as against the landlord, which is not quite the position here. And tenancy, the obligations on landlords in respect of repair in the private rented sector will increase. Those obligations will increase once this aspect comes in. The next part is, I'll deal with this the opposite way. So the right to keep pets. A landlord can only insist that a tenant not keep a pet if it's reasonable to do so. So you cannot unreasonably withhold consent to the tenant keeping a pet. There may be reasons where it is reasonable, but that will depend on the circumstances. It's not going to be a good reason to say it takes more cleaning, or there are residual issues with allergies, or the things that you may say now as reasons, but you cannot simply say no as a sort of policy. If they want to keep a pet, you do have the right then to insist that they have adequate pet insurance, that they pay for, and that any increase to your own insurance policies is met by them as part of that permission. You're also not allowed to to restrict your tenants to if with no DSS type clauses. I don't really see many of these around anyway, because I think the agents are very savvy, and you just wouldn't see this as part of your advert, or even as part of your policy, and that's obviously the right thing. You can still decline a tenant for a reason which is not discriminatory. So you can decline a tenant because they can't afford the rent. It doesn't mean that you must take tenants that are in a are accepting benefits or whatever. It just means that you can't discriminate against them as a group, as a blanket policy. I just saw a question flick up about reasons to refuse a pet. So it may be that your superior lease has a restriction on keeping a pet that you can't get around, and that means that obliges you to not keep a pet. So that would be a good reason. I think in those circumstances you would probably have to ask your superior landlord for permission. But putting you in breach of your lease, if your property is a flat, is a good reason for refusing. I mean, it may be that, we're talking about pets. Clearly, if someone wants to keep an alligator, that in itself might be a reason for refusal. But I think, dogs and cats and there will be reasons. I mean, it's difficult to say what is reasonable. It just depends. It's simply not liking pets is not going to be a good reason.
Yeah, I've got a question. If let's say I have a two beds terrace house, the garden isn't massive. My tenant wants to come in with 4 German Shepherds. As a dog owner, I know that house won't be suitable. They could argue that it is suitable because it has a bit of a garden space. What would happen? Where would it go?
Well, ultimately, that I think would be a matter for the tribunal if there's no agreement on that, and or the ombudsman. So I'll come on to that in a minute. But there's going to be a property, effectively a private rented sector ombudsman, that is going to be in place that will, I think, have jurisdiction to determine these kinds of issues, maybe. But I think what you've described would in my view, be a good reason to refuse. The property isn't suitable. Reasonable in legal terms always has a scope. It is not one answer only, and so you would take into account all of the circumstances, and at the end of your consideration of all of those, would an ordinary person think that was or rather, could an ordinary person think that is unreasonable, or think that refusal is reasonable? I'm being very vague, and I apologize in advance for that. But it is so difficult to define and really put your finger on what would be unreasonable, without knowing the facts.
I'm assuming in the legislation, when they finalise it as such, that reasonable won't be defined. It will just say reasonable.
So definitely not. And it will say words to the effect. I don't have the act in front of me, I'm afraid, or the bill in front of me, but it will talk about the landlord being forbidden from unreasonably withholding that consent. And we have precedent for that because in commercial leases, well, I mean, even in residential long leases, the idea of not unreasonably withholding consent is well established. So, you know, for things like alterations and for assignments. So it's not something new to professional or generally to the sector. It's just you just have to apply all the facts, and it may be that something that's a reasonable refusal for flat A might be an unreasonable refusal for house B. Um, Again, it just depends. Um, okay, so regulation and admin, extra admin for landlords. So regulation that you will have to, so you as a landlord will have to sign up to the digital private rented sector database, or whatever it becomes known as or called. And I don't believe that they have anything in place already. Uh, so whether that comes in immediately or whether there's a lead-in time for that, I'm not entirely sure. I'm also unsure at the moment whether that's going to be a local authority um, managed scheme or whether it's going to be a national database. So, whichever it is, every landlord, whether they have one unit or 100 units, will have to register um, on this particular database. Every landlord would, and it will give details of who you are, what you have in terms of your property, um, and allow the authorities to know that you are a landlord. Um, you will also, as a landlord, have to sign up to the Ombudsman service. Again, it is not known. We can speculate, but it's not known who will be that ombudsman. There is a property ombudsman already. There is talk that this PRS ombudsman might be tacked on to that responsibility. But there is also talk that actually it's going to be a whole new ombudsman service sort of set up almost from scratch. So again, that's a bit of watch this space, I'm afraid. But you will have to be a member. And they will be able to regulate and they will be able to make decisions in the way of any other ombudsman. So, and you will be bound by those decisions and you'll sign up to be bound by those decisions. And if you're not, or if you fail, if there is a decision that is made which you do not comply with, you can be removed from their register, which will mean that you cannot then act as a landlord. So it is quite a serious step. I've said here local authorities have greater enforcement powers. At the moment, local authorities can enforce against what I've called bad landlords. In particular, things like disrepair, failure to be registered as an HMO landlord, for example. But because of the extension of things like the Decent Home Standards, because of the extension of admin requirements and rules relating to how landlords behave with tenants, their powers, the local authority powers, will expand to become wider, and they can issue. The idea is that they will be able to issue even bigger fines than they can currently issue, and some of those can be up to £40,000. And bear in mind, when a local authority prosecutes in this way or enforces in this way, they're not seeking a judgment from a judge as to how much you should be fined. They are simply imposing a fine based on what they believe on their scale that fine should be. And that obviously will depend on how they view your transgression. So it can be up to £40,000 for a first offence. I think that's unlikely, but it can. So there are, obeying the rules is going to become a real essential uh, to that. Um, Rent repayment orders. I will mention this. So a lot of the new offences, if you like, so a lot of the new rules can put you in a situation where a tenant can say you're in breach of your obligations. So, for example, it currently applies to HMOs. So, if you don't have an HMO license but you're letting out a house as an HMO, the tenants can apply to court for a rent repayment order, or rather the tribunal, for a rent repayment order, which was that the rent that they paid you for that period where you've been in breach of your obligations has to then be paid back to them. Oh, it seems fairly draconian, but there you go. That will be increased because there's a wider range of offences. You failed to sign up to the ombudsman. You failed to provide a written statement of the terms of the tenancy. You've not had yourself on the register. At that point, the tenants can apply for these rent repayment orders and get back their rent, which could be costly. Can you go to the next one, please?
Sorry, Gary, can I just butt in? If a landlord is with an agent, will they also need to be part of an ombudsman service, considering the agent would be as well?
I think that they do have to be a member of an ombudsman service, but that is a point I'm more than happy to double check. And that, because it would make no sense for there to be a double a double registration, if you like. But I think because
It'll be a further cost, won't it? That's the thing.
It will be a further cost, but I think given you're with an agent, you can change agents. So it may be. It's something that I will check. I'm sorry, I don't have the answer at my fingertips on that one, but I will. I'll do a written response on that if I may. If we can go to the next.
That was actually it, Gary.
That's it.
You enjoyed yourself that much?
I've enjoyed. Oh my gosh! No, it is. You're right. More slides. I really have enjoyed myself, and that's exceedingly sad, and I apologise. But yeah, I'm more than happy to take some questions if that's how you want to address it, or we can have them in writing, and I'll respond to them afterwards. I'm in your hands, Lianne.
I have got a question myself. In the meantime, if anyone wants to raise a question, put it on the chat and then we'll answer it now. If anybody forgets or think about something later, send me an email and then I'll be happy to assist with Gary in response to that. Obviously, everyone is on an AST currently. And then what you're saying is that everything will go to periodic in effect. Will there be like a new type of periodic contract with different terms, or will all the terms for the pro? Or deliver?
My understanding is that the terms that you've agreed will continue, save for the term itself, as in the length of the term, which will change to periodic, and any in tenancy rent increases will also become null and void. So if your tenancy says after 6 months your rent raises by £100, then you can forget that. In terms of whether there's going to be a standard form of tenancy, there might be. So it's something that actually one of my colleagues is working on, I think, with some of the agencies that he works with. But the idea of there being so one of the things in the Act, sorry, I'm flipping right. One of the things in the Act is that a landlord has to provide statement of main terms. So if you suppose like a heads of terms, and there are certain things that have to be in that statement, it may be that the intention is for that statement to supersede or to replace ultimately, long tenancy agreements. I think there are things in tenancy agreements which, I mean, as a lawyer, we love a long document, but that's to try and cover everything. I don't quite see how a one-size-fits-all document is going to work, but it is definitely something that is being considered and may come into force.
Thank you very much. And my only other question as well, which I think would be useful, if somebody is taken to a tribunal, do you think at any point there will be sort of like a no win, no fee solicitor, as they do with the PPI, that sort of thing? Where is there going to be any more of that coming into play with this reform bill?
It's not something that I would be looking at. I mean, the difficulty is, I mean, you may get some sort of measure of that, but I mean, the difficulty is what's a win where it comes to tribunal. It's a serious point though. Where it comes to tribunal work, and for example, you're arguing about what's the correct rent. I mean, what's a win? Because the tribunal can give a figure of anything from, what the tenant's asking for up to what the landlord's asking for, and anywhere in between. So, I mean, it's difficult from a lawyer's point of view to say, right, and we're not in it for the goodness of our health. I mean, we are in it for the love of the game, of course. But we also need to run a business, and it's difficult to see how a no win, no fee is going to work with that kind of claim. And on the other side, where there's prosecutions, I mean, again, there's no win in the sense that the landlord isn't actually going to gain anything. All you're doing is trying to avoid a loss. And that, again, it's I don't know. I mean, we'll see how things develop, but it's not the thing that immediately springs to mind as being something that will definitely happen. I mean, look, lawyers are great ones for trying to drum up business, and if that is a way to do it, I'm sure we will. But I don't see a big market for that.
Cool. Thank you, dokie. That's the end of my questions. There is two on the chat, one from Peter and one from Gail. Gail has asked, what offences can tenants bring in an action for?
So rent repayment orders. So, crikey. In terms of rent repayment orders, it's more the failure of the landlord to act administratively properly. But things like failing to register, failing to, get an HMO license is the one at the moment. I think failing to register on the PR as a member of the ombudsman and on the database will be ones that a tenant can get rent repayment orders. If we're talking about other offences, so this goes back potentially to the disrepair point and the Decent Home Standard and AWAB's law. Tenants will, once that comes into play, will be able to enforce against health hazards, whereas now they're asking the local authority to do that. They'll be able to do it directly. I can see Peter has asked, are there any positives? It's not as bad as it could be. I think the fact that they've recognised. So in terms of being able to sell the property, that is a new ground. It's positive. I mean, how this is going to end in terms of where the act ends up. At the moment, if you get rid of a tenant on the grounds of uh, uh, wanting to sell, you then can't let it for a certain period of time, and it may be up to 12 months. So if you change your mind, that can be an offence. There are often, I mean, maybe you have every intention of selling, and something happens. So there are going to be grey areas, and I think that's something that maybe is going to be litigated and decided by tribunal stroke, the upper tier or the upper tribunal. I'm not sure. In terms of other positives, so the redevelopment ground that has been beefed up. So it is easier for a landlord to get rid of a tenant on grounds of redeveloping. I mean, from a land, this whole bill, this whole act, is the government's attempt to rebalance what they think is a landlord-friendly market and a landlord-friendly set of facts, set of legislation. So it isn't really aimed at helping landlords in any way. But I mean, it's going to be the new system, and a lot of it is already in place. It's just reuse other ways of going about things. And for me, one of the biggest issues is going to be getting tenants out at the end if something has gone wrong. And I mean, in fact, I see a lot of where it's gone wrong and not actually a lot of where it's gone right. So I'm slightly jaundiced. But where it's gone wrong, and you have to use the courts to enforce a possession order, I think without investment, it's going to make life very difficult. I mean, you could easily have a situation where you've had no rent for in excess of 12 months and you're still not got a hearing date. It's possible.
That's also still possible now, depending on what area of England you live in.
It is, but I think it's going to get worse. So the very fact that rather than having arrears of 2 months and 2 weeks, which is you get to your 2 months arrears point. Well, actually, that's going to be a month and a bit, isn't it? So you can get 6 weeks from someone not paying the rent and start the process, whereas it's going to be 10 weeks, 12 weeks before you can start that process at the earliest. So you've doubled the amount of time before you can start. Everyone is going to need a hearing in order to get possession. There's no more money in the court. So they're talking about digitizing. Nothing's happened. I mean, it's going to be difficult.
Do you see the court fees going up any more than what they already have? Because I believe it went up on the 1st of April, was it?
Yeah, I think it's £404 now. Do you know what? If it went up to double that, and they halved the amount of time that it would take to go through the process, I personally, I mean, I will take that all day long. All day long. But I mean, I don't think that there are no. This is the thing. There are no plans as to what to do next in terms of the cause. They're all. The minister is sort of. He's Pennycock, and his view is, it's all going to be okay. Don't worry. it's all going to be fine. The courts are going to manage. It's going to be fine. It's based on nothing. I mean, it's based on no studies. It's based on no nothing other than he presented the last quarter. It was showing 8 or 9 weeks to get a possession order. I mean, in what planet or corner of the country it takes 8 weeks? I don't know, but it certainly doesn't take that in the busier courts. Sorry, it's a pet project of mine to chastise the court where possible. But there we go. There's one here.
Yeah, I was gonna say again about about the mold. I don't believe anything's changing in respect of how we would go about managing this. Um, the courts want to see proactivity from a landlord. There is a lot of companies that offer free quotations from damp and mold specialists. If you get one of those out, and usually there is around a 4-week waiting list for them, in fairness, if you get one of those out, they'll provide you a really lengthy document blaming either the landlord and some works that needs to be carried out, or it will say it's due to a lack of ventilation. If you have everything in writing to them to say, you need to be maintaining this, this is what we feel is happening, and then they don't do it, and they've been told a minimum, I believe, of 3 times. The court's more in favour of the landlord than they are the tenant in those instances. But it's proactivity from a professional is what they're looking for.
Yeah.
Am I right in saying that, Gary?
Yeah. I mean, it's your problem as a landlord unless you can really show otherwise. I'm afraid. That's the gist of where it's going, because that's there have been some high profile cases with fairly bad consequences. When I say fairly bad, the worst consequences, in which the idea of mold is a landlord's issue. We all know that a property needs to be ventilated, but you've definitely got to take the steps that need to be taken as a landlord, and I would say go the extra mile where there's issues of mold.
It's a tick box exercise, unfortunately.
Yes. Peter, no, there is not going to be a tenant register, sadly. Hi. So that was the. And no, I don't know when it will come into effect. I mean, back at the start of the year, we were thinking even May. I think the reality is it's probably end of Q3, beginning of Q4. I do think it's going to be 2025. But in fact, I think the final Lords process has been conducted already or is about to be. So it will be going back off to the Commons, who will chuck out all the amendments apart from their own, and then send it back to the Lords and say, get on with it. So it could be as early as September.
Have you got any advice for anyone other than obviously what you've already highlighted in your slides? Like, what do you think is really important at this point?
I think if it's really difficult, and there is a danger that landlords who are not, or institutional landlords who have lots and lots of properties are going to be driven away from the market by this legislation. And that's a distinct danger, because it's not going to be pretty. And I think if you have numbers and if that's your business, you can probably fit in around what's being required. And if it's not, and you're a part-time landlord or an accidental landlord, then it's going to be difficult. I think if you have big question marks about your tenant, and I might get rid of them, might not. I mean, you have a window of opportunity to serve a Section 21 notice. Any notice that's served now, or up to it coming into force, will still be able to be relied upon post it coming into force. So if you served it now and it comes into force next week, you can still issue a claim based on that notice. So perhaps to curate your tenants list probably sooner rather than later. I mean, again, I'm jaundiced because I see the bad ones, but most tenants are fine. I mean, most tenants are good tenants. They will pay. They will, help you out, and it's a relationship. But there are some, and it's the ones that I see. There are some that are not, and putting them out of your property is going to be an awful lot harder come the end of the year. That's all I'd say.
I think girls we're seeing another question. Other than that, I think we were almost done. Have you got any questions, Chris?
Can't send the heavies around anymore.
Did you hear that?
No, I didn't hear what say.
He said we can't send the heavies around anymore. Not like we would.
I mean, obviously, we could never do that. In recent terms. But no. That's not gonna cut it. You can't even send the notices around. Never mind the heavies. In fact, Gail's question is very much your bag, Lianne, not mine.
That is indeed. Yes, there is. We always do take a landlord reference, Gail. I don't believe in them. The reason being, if you have a pain in the ass tenant and you're desperate to get rid of them, if another reference comes in and says, "Are they a good tenant?" you're going to say yes. What we do, however, is we use AI to check against their bank and their contract. If they are more than 3 days late, twice in a row, they will fail referencing on that and that only. If that helps. You can tell I say that a lot.
Yeah. What a fantastic use of AI.
Yep, there you go. Yes, it would. We as us as an agent, we would always recommend people with rent guarantee and legal cover. Because this process, as Gary's always said, can be long and expensive. Would be sort of where we are, our standpoint on it anyway.
Yeah. Yeah, I think it's going to be a sea change for agents, for landlords, and for us as lawyers. And I think just try and understand it as best you can before it happens, and I suppose expect a little bit of turbulence once it comes into force. But it will so sorry. It will it'll be okay, I think.
I agree. Cool. All right. Well, thank you so much for your time, Gary. Thanks for joining us, and thank you everyone for attending. If you do have any questions in the meantime, or think of anything overnight, please feel free to write me an email, and I'll respond as soon as I can. Peter and Gail are both writing again, so we'll just wait for them, and then we'll say our goodbye. Yeah. Thank you very much, Gail.
Thank you to you guys as well. I really appreciate it, and appreciate your time. Thanks.
All right, that's it. Thank you.